Leader of the Opposition.
Thank you, Mr Deputy President. I lead for the Opposition on the Criminal Legislation Amendment Consorting and Restricted Premises Bill 2018. The Opposition does not oppose the bill. The objects of the bill are to amend both the Crimes Act and the Restricted Premises Act in response to reports by the Ombudsman. This legislation has been carefully expressed to be in response to the reports, not to adopting the recommendations in the reports, because the provisions of the bill are in a number of respects at variance with the content of the reports. The first of these reports is by the Ombudsman relating to the consorting provisions of the Crimes Act. The report was tabled in June 2016. The second was the report by the Ombudsman relating to some of the police powers and offences under the Restricted Premises Act. It was tabled in the other place in November 2016. So 2 years or more after the reports were tabled, legislation has at last appeared. Now, I note that the attorney in the other place made the defence in his reply speech that the government did not want to rush such important reforms, but preferred to take a considered approach. Mr Deputy President, I could understand that if it were a weighty undertaking like the Uniform Evidence Act or some entirely new piece of legislative edifice, but to take such a long period of time to deal with these two reports shows a government lacking an agenda and lacking perhaps the competence and wherewithal to actually proceed expeditiously with these reviews. The end product suggests that the period between the tabling of the reports and now has been taken up by bureaucratic struggles over the provisions of the bill, which certainly seems to be the case with the consorting provisions. The provisions of the bill do a number of things. Offences committed outside the jurisdiction can make someone a convicted offender for the purposes of the Principal Act in relation to consorting. Any person under the age of 14 is excluded from the offence of consorting. A clearer statutory form of the consorting warning is provided, although lack of strict compliance does not apparently invalidate the warning. An official warning expires 2 years after it is given, or for someone under 18 years of age, 6 months after it is given. And the defence of reasonable consorting is extended to consorting that occurs while complying with an order by the State Parole Authority or complying with a case plan, direction or recommendation by Corrective Services New South Wales, or providing transitional crisis or emergency accommodation or a welfare service. The defence of reasonable consorting between family members now takes into account the Indigenous kinship system of an Aboriginal defendant's culture. There is also a requirement that the Law Enforcement Conduct Commission reviews the amendments made by this bill within 3 years of the commencement of the provisions. The LEC is to report both to the Attorney-General and to the Minister for Police as to the outcome of the review, perhaps a worthwhile safeguard given recent events. Consorting laws in this state have had a long, chequered, unpleasant and contested history. They were introduced in the 1920s, ostensibly in response to the Razor Gang phenomenon, primarily in East Sydney. They grew from the vagrancy legislation which simply targeted the poor. They fell into disuse and were certainly an element in police corruption, as was recognised by the Wood Royal Commission, and that situation arose from the very wide discretion allowed to individual police officers. This Parliament amended the law relating to consorting by the Crimes Amendment Consorting and Organised Crime Bill 2012, which commenced operation on 9 April 2012. It was subject to a High Court challenge instituted in 2012 and finalised in 2014. That 2012 Act provided for a review of the operation of the provisions, and the Ombudsman's report to which this bill responds was the result of that review. The original review was to be 2 years after the commencement, but that was extended to 3 because it was assumed the High Court proceedings would have reduced the use of the provisions. The Ombudsman's review covered the period 9 April 2012 to 8 April 2015. Consorting as an offence does not sit easily within the usual range of criminal laws. It does not punish someone for a criminal act per se, but is aimed at stopping people committing criminal acts in the future because of who they associate with. It does by targeting what could be ordinary, regular, innocent relationships which, on any rational view in other circumstances, should not be the subject to the intervention by the criminal law. but the wide discretion involved and the consequent potential for it in previous times, the actual occurrence of corruption, means that care should be exercised in designing and implementing laws of this nature. This law can criminalise otherwise innocent behaviour and tries to control future conduct without demonstrating that someone is involved themselves in criminal behaviour. A majority of Australian jurisdictions have consorting laws, a point made by the attorney and the shadow attorney in the other place during the debate. Item 3 of Schedule 1 to the bill amends Section 93 capital X3 of the Crimes Act relating to a warning to be given. It is said to more closely mirror the elements of the offence. It seems to respond to recommendation 2 of the Ombudsman's report. It does not seem to completely correlate with the Ombudsman's recommendations, which in turn was the same as the New South Wales Police Force submission to the Ombudsman's review. If the Ombudsman and the police agree, it is curious that the government does not. And I note that the attorney in his reply speech in the other place said that the Ombudsman's recommendations had to be considered in close consultation with the New South Wales Police because of the operational impact of any changes to consorting law on law enforcement. I note the attorney in the other place also said that the warning proposed by the Ombudsman in recommendation 2 of the report was not correct because of some technical analysis that the attorney then engaged in, and says that the warning in this bill was developed in consultation with the police force and the Parliamentary Counsel's office. It still does not really explain why the government's actions here differ to the Ombudsman's recommendations, given that the Ombudsman's recommendation was congruent with the submission of the police. So an explanation of that would be useful, particularly should these provisions be judicially applied in the future. Given the lack of clarity, it would be useful for the government to outline the deviance or the diversion from the recommendations in this bill. The proposed Section 93X4 also arises from the Ombudsman's report. An official warning ceases to have any effect 6 months after the warning is given to someone under 18, or in other cases 2 years after the warning is made. This issue arose as a practical one because of the 2012 legislation made consorting an indictable offence when previously it had been a summary offence, with a set period in which prosecutions had to commence. There is no such limit on indictable matters. The police sensibly dealt with this as a matter of policy by deciding that criminal proceedings for consorting should not commence unless the occasions of consorting occurred within a 6-month period, unless in exceptional circumstances. Most other jurisdictions in Australia also contain time limits. Recommendation 9 of the Ombudsman's report was that the attorney proposed for consideration by Parliament an amendment to the consorting laws to include a statutory time limit. Proposed Section 93X4 effectively achieves that objective, we think. The Ombudsman made a number of recommendations concerning defences to a charge of consorting. It's worth noting that the Principal Act places an onus on the defendant to establish a defence, reversing the onus in a way usually frowned upon in our system of criminal law. The Ombudsman records the views of submissions to his inquiry that the existing defences are not extensive enough and exclude a range of circumstances that ought to be included, such as consorting in the course of sporting activities, religious activities, or between neighbours. Recommendation 12 proposes amendments to Section 93Y of the Principal Act to provide additional defences. Items 4 and 5 of Schedule 1 to the bill seem to do precisely that. Recommendation 13 proposes a definition of family members that includes kinship relations between Aboriginal persons, as I indicated earlier. That is contained in the proposed addition to Section 93 capital Y in the definition of family. Another amendment to Section 93Y seems to deal with Ombudsman Recommendation 14 that would allow consorting as part of attending a health service that includes therapeutic rehabilitation, drug and alcohol services. Now, the shadow attorney did ask that the attorney explicitly confirm in his reply the Ombudsman's Recommendation 14 had been implemented in the bill. I didn't myself find that confirmation in the attorney's reply. I may have missed it, but it would be again useful if the government attended to that matter in this place, or at least just point out my oversight. Preventing people seeking drug rehabilitation services because other people there might have committed criminal offences does seem genuinely bizarre when you consider the chain of circumstances often leading people to seek such rehabilitation services. Item 1 of Schedule 1 includes as an indictable offence and brings within the consorting regime an offence committed in another jurisdiction that would be an indictable offence if committed in New South Wales. That does not appear to have come from the Ombudsman's report, but it's not objectionable. Schedule 1 Item 7 provides a review provision with the review to be carried out by the Law Enforcement Conduct Commission, also consistent with the Ombudsman's recommendation. The final provision in the bill dealing with consorting is the proposed addition to 93X1 in Schedule 1 Item 2. This would exclude from the consorting regime anyone under the age of 14. There is currently no age restriction in the Principal Act, so this is a new restriction and a removal of one group previously included in the consorting regime. The opposition finds it a troubling proposition. The Ombudsman's recommendation was for an exclusion for every person under 18 years rather than the New South Wales Government's proposal of under 14 years. The New South Wales Police adopted as policy that consorting charges should not be brought against those under 16 years of age unless in exceptional circumstances. The government's proposal is not only less restrictive than that proposed by the Ombudsman, but also less restrictive than that proposed by the police. Now, I note in his reply speech, the attorney in the other place did defend the approach taken by the New South Wales Government with this statement, and I quote him, "Excluding people under the age of 18 from the consorting law may also result in certain young people being more susceptible to exploitation by organised crime groups." And of course, the statement that the government approach was more consistent with the law of criminal responsibility. It doesn't explain why the New South Wales government policy in this bill departs from that proposed by the Ombudsman and the police. I don't think either of those bases advanced by the attorney in his reply speech gets to the pitch of the ball, Mr Deputy President. And again, I would ask the government in this place to give a more lucid and full explanation of these important departures. Because this goes to the core issue of what the consorting laws are in fact intended to do. They're explicitly introduced to be utilised against serious and organised crime. That was very explicitly what then Premier O'Farrell said, as did other speakers from the government side. In the debate and public discussion, that was unequivocally the Parliament's intention. It was contained even in the title of the 2012 bill. It has been restated in the attorney's second reading speech introducing the bill in the other place, and I assume in the minister's second reading remarks here. So what is going on that people as young as 15 are supposed to be subject to consorting warnings and even charges? This reflects the fact that a significant use of consorting powers by the police in fact appear to have nothing at all to do with organised or serious criminal activity. Quoting from page 30 of the Ombudsman's report, General Duties Police attached to LACs were responsible for issuing 4,401 official warnings during the review period, amounting to approximately half the total number of warnings issued by police. These warnings were issued to 2,268 different people on 1,538 separate occasions. Overall, 2,601 different people were subject to use of the consorting law by General Duties Police officers, amounting to 79% of all people subject to use of the consorting law by all police, unquote. Just pausing there, it doesn't seem to be the purpose for which the Parliament created the law. It'd be good if the government could explain how this law is being applied and why it's being applied in a way quite differently to that intended by the Parliament. The use varied dramatically between different zones and different local area commands, suggesting significant elements in the LACs did not see the need to use the consorting powers at all, while others obviously did. It's clear that much of this had nothing to do with serious or organised crime, and it's in stark contrast to the gang squad who used the powers in what seems to have been exactly the way intended by Parliament. So They also used it differently to general duties officers in ways set out at pages 32 to 34 of the Ombudsman's report. If the powers are being used other than for serious and organised crime, it can perhaps then be understood why children have somehow got caught up in the use of the consorting laws. But the question is this appropriate? During the review period, the Ombudsman advises 201 children and young people between 13 and 17 years of age were subject to the use of the consorting law. 41 were aged between 13 and 15 years, and nearly 60% of them were Aboriginal. Another very disturbing metric. Quite remarkably, though, 79% of these warnings to children and young persons were illegal, which is perhaps even more alarming. Police being given these important powers not being applied lawfully. This was almost exclusively done by general duties police. Only 7 of the 201 were targeted by specialist squads. The Ombudsman quotes evidence from a regional director at Juvenile Justice that it is unlikely the use of the consorting powers will in fact reduce juvenile offending. The extraordinarily high error rate suggests something has gone badly wrong. Of 133 children and young people in the consorting data whose associates or friends were warned about consorting with them, 105 were incorrectly identified by police as convicted offenders. I quote the Ombudsman at page 80. It appears that police are issuing consorting warnings in relation to children and young people who are known to them through a repeated police contact, and that these mistakes have arisen from a lack of understanding by police officers of the restrictions on the children's court's ability to record convictions, unquote. The Ombudsman notes that there is evidence that these mistakes by police continue. However, the Ombudsman does quote at page 81 of the submission from the police that concedes that the issue has some impact on the usefulness of consorting powers in relation to those under 18 years of age. That is, there are only very limited cases where consorting powers can legally be used against young people. The police submission at page 82 of the Ombudsman's report went on to say that the consorting powers should be available against persons 16 years or over who commit serious indictable offences. Again, the police posit an age of 18, but the government's bill is 14. I quote from the Ombudsman at page 83, quote, "There is agreement amongst all the submissions that the consorting law should be amended to exclude its application to children aged 15 years and under. However, we are of the view that the consorting law should not be used in relation to any children and young people, that is anyone who is not yet 18 years old," quote unquote. Again, the reason advanced by the attorney in the other place is not sufficient or compelling and really obscures rather than clarifies why the government has landed on this policy. The reality is that children can only very rarely be lawfully caught by the consorting regime as conceded by the police, all of which means that the government position is confused and certainly confusing. A bit of light being shone on this by the relevant minister in this place would be most useful. There is an Ombudsman's report saying that very rarely can this be legitimately used against children or young people. Then there's a piece of legislation that says we'll put an age limit of 14 on it when the Ombudsman says 18 and the police say 16. It's just all over the place. Turning to Schedule 2 of the bill, which deals with amendments to the Restricted Premises Act, the Act originated as the Disorderly Houses Act. Whilst consorting laws dated from the 1920s and the razor gangs, the Restricted Premises Act originates with the Second World War and considerations of national security. In July 2013, the Labor opposition introduced a private members' bill, the Firearms Amendment Prohibition Orders Bill 2013, to deal with people subject to a firearms prohibition order. Shortly after that, and in response, the then Premier introduced the Firearms and Criminal Groups Legislation Amendment Bill 2013. Apart from having provisions similar to the Labor Private Members Bill, it also contained provisions amending the Restricted Premises Act. These provisions expanded the existing search powers in the Act to enable police to search for weapons and explosives, as well as to search for drugs, alcohol and related items, which they already could. The amendments also created a new category of, quote, reputed criminal declarations, unquote, and 2 new indictable offences that could be committed by owners and occupiers of declared premises of failing to prevent a reputed criminal from managing, attending or controlling the premises. That legislation was required to be reviewed by the Ombudsman for the 2-year period 1 November 2013 to 31 October 2015. Schedule 2 to this bill seems to largely consist of provisions adopting the report's recommendations, which is interesting because the police seem to have gone to some trouble to fail to provide all the information requested by the Ombudsman, which the Ombudsman thought was relevant to the review. The expressed aim of the government's legislation, apart from running over the top of the Labor Private Members Bill, was to, and I quote, make it easier for police to get premises declared on the grounds they were routinely used by serious criminals such as gang clubhouses, unquote, according to the then Premier Farrell. Now, in the debate in the other place, the Shadow Attorney referred to one application being made concerning premises at Leppington, which was withdrawn when the use was altered. The attorney, in his reply speech, did say that the powers under the Restricted Premises Act have been used against bikie clubhouses being declared as restricted premises. He also indicated that from October 2017, the New South Wales Police Force had used this power to enter a declared premises without a warranted 14 times. Now, I'd asked the government in this place to indicate whether these are the only occasions where this has been used, and whether they've been used more recently and in what circumstances. It would be useful to understand how this legislation has been applied in practice, because we don't seem to have much visibility of that, which, considering this House and the Parliament's being called upon to enact new laws, without that information, it should be a matter of public record at least, or at least that information. I understand there may be some operational reasons why you wouldn't want to give chapter and verse, but there certainly should be more information than we currently have. There were apparently 7 occasions when police obtained warrants under Section 13. Police can apply for a warrant under the section before applying for a declaration if they have reasonable grounds to believe that prescribed activities are taking place at a particular location. Material gathered is meant to be used in preparing an application under the Act. Section 13 search warrants were executed during the review period on premises in Girraween, Bullaroo, Newcastle, Woy, Leppington, Warwick Farm and Burwood. The Section 13 searches seem to have led to the closure of motorcycle gang clubhouses. Despite Parliament's expectation, declarations were not sought or needed. All these 7 locations were gang clubhouses. Many other clubhouses were not raided. This is apparently consequence-based policing. The police do not target clubhouses generally, but only those in response to particular reasons. The exercise of the Section 13 search warrants has given rise to recommendations by the Ombudsman, which are adopted in the bill. Recommendation 2 is contained in proposed Section 13 A, as is Recommendation 3. While executing a Section 13 warrant, the police may give a reasonable direction to a person on the premises to minimise risk to any person, and it's an offence not to comply. Given that the situation involves such circumstances, these provisions make perfect sense. 60-odd people present, for example, at the Rebels Clubhouse at Leppington when a warrant was executed, is a situation where the need for such powers being clarified seems logical. Proposed Section 13 A, B implements Recommendation 4 of the review, giving the police the power to search any person on the premises whom they reasonably suspect of having in their possession something mentioned in the warrant. Recommendation 5 is replicated in proposed Section 13 A, C, a power of the police to demand a name and address of anyone present during a Section 13 search. Proposed Section 10 is amended by Schedule 2, Item 4, in accordance with Recommendation 9, so that police must notify the occupier of premises searched under Section 10 of the search if they were not present, which is a useful clarification of the provisions, although there was no use of the additional Section 10 powers during the review period. Items in Schedules 2, Item 1, and Schedule 2, Item 2, and Item 3 make amendments to Section 4 of the Principal Act to allow for the rescission of a declaration on the application of the owner or occupier of premises. The changes introduced by Schedule 2 seem comparatively non-controversial and in line with the recommendations of the Ombudsman's report. The opposition does not oppose the bill, despite the confusion and lack of clarity on the part of the government, but we do ask for the clarifications that I have sought and identified.